Welcome to the Seattle Investors Club podcast with Julie Clark and Joe Bauer, where we share the nuts and bolts of real estate investing from our 20-plus years in the industry. Sit back, relax, listen, and immediately take action. Are you ready? Here we go.
Welcome to the Nuts and Bolts of Real Estate podcast. My name is Joe Bauer, and I'm here with my co-host, Julie Clark. Julie, how you doing today?
Joe, I am doing good because it is the first day of school in my house, and we are getting back on a schedule. Woo, woo. Yeah, that's what I'm talking about. First day of seventh grade for Katie and Addison today. And we had a spectacular summer because after all these years, you've rubbed off on me so hard. We were pretty much in the mountains and the rivers and on bikes all summer. We probably had the best summer that we have had in years, despite all the craziness in this world. So I am energized, aside from the 20 ounces of coffee that I drank before I jumped on here. So what's up with you, brother?
Ooh, I am just hanging out, trying to enjoy the last little bit of summer as well. We're actually in Enumclaw, so The weather is the same for you and for me. But I'm interested in knowing if you have a highlight or two from the summer adventures.
Oh boy. You know what? We found so many good finds. I will say, I'm going to do a post about this because we hit some great spot. The number one find that we found this summer, I don't know how we didn't know about it before, is the Green River Gorge swimming hole. I don't know if you guys have been there. You go through Renton, through Maple Valley, like 22 miles past Black Diamond, just east. And I can give you the instructions if you're interested. Somebody hit me up. You guys know how to find me, but it's not a hike or anything other than down some rickety old kind of staircase that leads you down to the gorge. But it is rope swings, cliff jumping. It is unbelievable. It is the best place. In fact, we might even go there this weekend, even though school has started. So we love that. And then of course, we just came back from Mount Rainier, and here's a plug. These brothers, they owe me something. We stayed at this place called the Stony Creek Lodge, Stony Creek Cabins in Ashford. There's like this property owned by these two brothers. There's like 12 cabins, beautiful grounds, and it's right outside I guess that's the Nisqually entrance in Ashford. Right. And we hiked Mount Rainier for 3 days this last week. It was super awesome. And we found a new swimming hole up there, too, off the Silver Falls Trail, just kind of off the beaten path. So those are the highlights. And of course, I think in the next 10 years, whenever I wind it down here and just run a full referral business, I might move to Bend because we loved it. Yeah. Meet you there. Bend, Oregon was the bomb. Love that. Spent some time there. How about you? Quick highlight.
Ooh, we just spent some time in McCall, Idaho.
Yeah.
And it's kind of like remind us a little bit small town Chelan-esque with like the style of foliage and trees that are around. And the mountain biking was off the hook. Like some of the best mountain biking of the whole summer. And we've been some legit spots.
Oh man, I didn't realize that McCall was such a mountain biking mecca. We actually went there for spring break one year. Love it. Faux show. Well, let's jump into it, guys, today because we have a lot to talk about. I can't help every time I look at our guest's name today, little sidebar, our guest is Kaitlyn Jackson, who's an attorney with Dimension Law Group out in Tukwila. But Kaitlyn Jackson, that reminds me of Kate Jackson and what are they called? What were the three gals?
Charlie's Angels.
Charlie's Angels. And my daughter Addison just got her haircut the other day. She comes out of the haircut place and I go, oh my God, you look like Cheryl Ladd, her little haircut with her bangs and all feathered blonde hair. It was so awesome. So looking at your name makes me think of Charlie's Angels. But transition, you are our angel today because you're going to save our asses from doing everything wrong, wasting our time and money by managing our tenants, whether that be evictions, rent increases, disputes, or anything in real estate. Today, we're going to be talking about, tenant landlord laws and get a more clear understanding of the current rules and protections in place for tenants or landlords so we can move forward to resolve any of our challenges that come up here as we move forward in our crazy society that we're living in today and dealing with all these things. So everybody help me welcome Kaitlyn Jackson again from Dimension Law Group in Tukwila. Kaitlyn, what's up?
Hello. Thanks for having me today.
Yeah. So, if you guys aren't aware of Dimension Law Group, they're like our favorite go-to. We recommend them all the time. Their practice covers real estate business, estate planning. And I think, Kaitlyn, your area of focus, I'm cheating off your websites, business law, commercial and residential real estate, landlord tenant matters, and estate planning. Does that sound about right?
That's about right. Though I will admit that throughout 2020 and this year, it has significantly shifted more into landlord tenant law, given all of the significant amounts of changes. It's kind of like you either have to be all in it or not in it at all.
I hear that, right? And that is exactly this podcast. The show couldn't be coming at a better time as we're reaching the end of, I don't know, we're going to find out. Are we reaching the end of any of the protections? Are we going to be having, as landlords, are we going to be able to move forward with anything at this point? We're about to find out. So again, like I said today, we also, I guess the joke we were making before we got started here, guys, is part of our goal today is helping to avoid you having your file on Kaitlyn's desk. Try and give you some seeds planted here to point you in the right direction so you don't waste a bunch of time going down the wrong path. So you have to start over or upsetting your tenants or yourself and causing more grief than this whole situation has already caused. So that's one point. And another thing is we want to make sure that we know that we're tenant and landlord friendly here. And we want to help the tenants, as I'm sure I'm a landlord, all you landlords would love to do, because we love people and, we're all humans and we want the best for each other. And so with that in mind, I'm going to remind you, and I want to put it out there before we get started on talking about how to evict people or anything else, that we care. Okay. And that means that people need to have jobs so they can pay their rent and have peaceful lives. And we have two places right now that we want to mention where you can find jobs, your family member, friends, or you can suggest to your tenants to help them find jobs. And one of those, as you might have heard before, is the hidden job market that we discussed with our buddy Dion McNeely on one of our previous podcasts. Okay, I'm not going to go into detail on that today, but Joe, you're going to drop that in the show notes?
Yep.
He will do that. So you guys can grab that. It's called Hidden Job Market with Dion McNeely. It's amazing that you don't know certain jobs are out there, and we're going to help you try and find those. Another one, Joe, I sent you an email if you didn't see it yet today, that there is the International Rescue Committee, which is located in SeaTac, is currently hiring lots and lots of jobs. And Joe will drop their job board basically into the show notes as well. As we all know, there's a crisis happening across the globe with immigrants, especially in Afghanistan right now. And if you'd like to get involved, one of those ways is to tackle two birds there with one stone, help people and get a job with the International Rescue Committee. So check the show notes or look up International Rescue Committee and let's get you guys going on there. So that's enough of my soapbox. Okay. And before we start, we're going to actually do a webinar today with Kaitlyn. But before we do that, Kaitlyn, I'm going to let Joe kick it off with our usual number one question so we can get to know you better.
Yeah, Kaitlyn, we always like to do a deep dive to get to know people better. So if you could take us through like where you grew up, how you grew up, all that fun stuff that led you to where you are today, we'd love to hear about that.
No problem. Okay, so where I am now is, as you guys mentioned, is an associate attorney at Dimension Law Group, special or practicing in the area of landlord tenant law, among other areas. Where I started, however, was from birth pretty much being raised in open houses. My grandfather started All American Homes out of Federal Way. He was the managing broker there, and I think the founder. And my parents, my aunts, my uncles, everybody was brokers, or were brokers that worked for All American Homes. And so real estate investment has been my passion since I was very young. And I actually bought my first property prior to going to law school. And I think that was somewhere around 2010. And that was my first investment to help me finance my legal endeavors. And it worked very well. Awesome. And so then I went to law school, and now I'm practicing in the real estate sector. And my passion is helping people navigate landlord-tenant laws as they come down, to make sure that, once again, their file stays off of my desk.
I love that saying. I'm going to steal that. That's a good one.
Yeah, that's why I'm here.
Good stuff. Well, we will hopefully be twisting Kaitlyn's arm in the future to join us on our Thursdays once in a while, whenever she can. That's Thursdays at 11:30 to 12:30. I think you guys know by now we host a weekly roundtable meetup. But I digress, and we're going to turn it over to Kaitlyn. Now we're going to jump into this to get you guys educated and keep your files off her desk. Let's do it.
Great. Okay, so I'm going to share my screen here in a second, but I want to mention that most of the materials that I'm going to be sharing today are statewide focused rather than Seattle focused or any particular city focused. As many people probably know, the local municipalities have been creating their own codes and ordinances that touch and affect landlord-tenant law pretty specifically. So the information today is going to be more statewide and general, but if you want specific information about your specific property, you need to talk to somebody, probably an attorney that practices, in that particular city or county. The materials were created in partnership with the Rental Housing Association of Washington, and they help provide lots of information, materials, classes, resources for being a landlord in the state of Washington.
Hey, Kaitlyn, question for you. Yeah. Would it be fair to assume, which is not a good word in law, I'm sure, but that the city ordinances or overlays, I guess I'll say, for each particular city in regards to what we're talking about today, are they more, maybe I could be wrong, are they more stringent, or are they looser, or is it a mixed bag? Do you know?
Well, I think it depends on where you're at. Some of them that were created pre-pandemic are probably looser because the pandemic actually resulted in a lot of statewide legislative changes. So those ones are probably not as strict. If it was created during the pandemic or, looking into post-pandemic for some of the Seattle stuff, it's probably more strict than the statewide stuff. And then the county-wide ordinances are usually more strict if they were, same thing, created post-pandemic or during the pandemic. So we got essentially the way I understand it and the way I see it is the only reason for the county or the city to act was because they did not think that the state was doing enough.
Got it. So when somebody is reviewing their situation, they go federal, check county, check city.
Federal, check, state, check, county, check, cities, check.
Gotcha.
Now, in terms of county, generally speaking, a county ordinance is only going to really affect those properties that are unincorporated.
Gotcha.
So King County has passed some ordinances. And so if your property is actually in Seattle, it is in the city of Seattle. So you'd probably go straight to, skip the county and go straight to Seattle. Gotcha. For the ordinance information. If you have an unincorporated property out in Maple Valley, however, that's going to be something you're going to go straight to the county for.
Makes sense.
Okay. Share screen. All right. Hopefully you guys can see this okay. Let's see. Okay. All right. So I'm just going to start with once again, not sort of plugging, but recognizing that my information I'm sharing today was made in partnership with the Rental Housing Association of Washington, who they host a lot of classes. So that's a good resource to go to if you need more information, especially specific information. So the big hot topic issues this year or through 2020 to 2021 are the statewide bills that were passed in the beginning of the year. So this started around April during the legislative session, but we have, Senate Bill 5160, which was effective April 22nd. It includes the eviction resolution pilot program and court-appointed counsel for indigent tenants. And those are very, very big changes to landlord-tenant law that will be affecting how we move forward with non-payment of rent cases in the state of Washington for a very long time, if not permanently. It's my impression that I know that the eviction resolution pilot program has the word pilot in it, but it's my understanding that the goal is going to be to make that permanent. And we will get into more specifics about what that looks like as I get further into the presentation. Then we have House Bill 1368. And really what that was the COVID funding. It was $365 million in rental assistance to be distributed by the counties. Mind you, many of the counties are way behind in distributing these funds. I think that there was a Seattle Times article out recently that said that King County had only distributed something like 4% of its funds. And while I think Pierce and Snohomish County are somewhere, and don't quote me on this just because it's been a while since I've read the article and I've read a lot of things since then, but something like 40%. But yeah, so it's county by county where they're at. And then there's House Bill 1236, which was effective May 10th, 2021. This is the just cause ordinance, which basically took the sort of outline that Seattle has been using for a couple years now, to make any termination of a month-to-month tenancy, only allowable under certain circumstances in Washington state if you have certain just causes. And then there's also some provisions that appear to be a mandatory lease renewal. How those are shaking out, these are very, very brand new laws that have not been, tried and tested in litigation yet. So we will see how some of the interpretations from the court come down. Hopefully the goal today is to not have you be that case. That's always my goal is don't be case law. Don't find your file on my desk. So we're going to talk about right now. So at the time I created this, it was the proclamation 20-19.6 was in place, but that expired on June 30th. Now the intention of the legislature in, I think it was 1236 or 5160, was that the proclamations would no longer continue. As many people were aware, the original proclamation that prohibited evictions or terminations of tenancies in Washington state was 20-19.1, and then the extension 0.2, 0.3, 0.4, 0.5, 0.6. And the legislature essentially said, no more proclamations. They shall expire on June 30th. However, what we found was that on June 30th, the governor decided to create a new strain of proclamations altogether. That's the one that's in place right now, which is Proclamation 21-09, I believe. And that one is a little bit different than what was in place under the previous proclamations. So as we all remember and experienced that during 2020 and some of 2021, you could not terminate any tenancies without, very, very limited reasons why or processes why. And you could not, basically evict anybody unless there was, a specific significant health and safety risk under some circumstances, especially in Seattle. That was pretty much the only reason. Now, under 21-09, you may move forward terminating tenancies under certain circumstances that are not a significant health and safety risk. However, non-payment of rent evictions are still pretty much prohibited. I'm not going to get into the details of 21-09 in the sense that The proclamation itself has language that is inherently confusing, and many attorneys are battling over its interpretation currently. But the nuts and bolts of it is that unless the county where the property is located in has verified or attested that its rental relief programs are fully up and running, and its dispute resolution centers are fully funded and up and running, and it's got its local, what they call it, it's like a judicial order for the eviction process published, you cannot serve even a 14-day notice to pay rent or vacate. It's my understanding that there may be 2 counties in the state of Washington that have that process moving forward. Most counties are not. The reasons for which are muddy. So
unless those counties all have their shit together, for lack of a better word, you're stuck.
Yes. So unless all of those things are true, and believe me, it's confusing to say the least about whether or not it is true, because what the Proclamation 21-09 created was basically because there's 39 counties in the state of Washington, is 39 different processes for evictions in the state of Washington, or 39 different programs that have to be individually assessed and verified. And there is there's no way to really force the counties or the local dispute resolution centers to actually submit the proper paperwork or attestation that they are up and running. So even if in all intents and purposes they are up and running, if tenants are able to access them and pull funding out and move forward, with a voluntary participation in their dispute resolution center, even if it's functioning at, in full capacity, if you will, if they just haven't provided that attestation, it means that the landlord can't force it if the tenant doesn't want to engage in it. So it's a little bit confusing for landlords in the situations where maybe you have a team of landlords who are talking to each other in one county, and one has a series of tenants who voluntarily participated in a dispute resolution center, and one landlord whose tenant refuses to communicate at all. The tenants who are voluntarily accessing those funds, everything's moving forward and their program seems to be, functioning. But unless that DRC has actually attested in a public website and gone through these, procedures to say, yes, we are ready, the landlord whose tenant is not communicating at all and refuses to participate in any way is still inhibited from actually starting the process.
So we're talking about evictions for non-payment of rent are in a stall because these counties can't get their stuff together.
Can't or won't is a dispute.
Can't or won't, right? But the point is no evictions for non-payment of rent.
Right, and in the strong majority of counties in Washington State, yes.
Is it? Exactly. Yeah. Is there? I mean, the biggest counties over here that we're dealing with are King, Pearson, Snohomish, maybe Thurston. Are they on the we don't have our stuff together list?
I think Snohomish may be. I think as of last week, I was seeing some movement in that area. Pierce, no. And King, no. And King, I think, is the biggest. There's some pretty significant information that we've seen that they're not motivated at all to start evictions. The way that the way I would say our politics work in King County is, why would we attest to something that would create evictions? Why would we do that? So they're probably I know they have a dispute resolution center. I know they have access to funds. I know they have funds. We know this. They have all the tools in the toolbox, if you will. But they're not ready to get to
They don't have the will. So the message here, guys, is if you have rentals in Snohomish County, it's worth a check and a follow-up to see if they are within the group of slim to none that actually have their shit together and are allowing evictions for the reason of non-payment of rent.
And I will go over some of the more specific steps that have to be followed. And I don't want to give the impression that, the the helpful thing here is that the only person, in my opinion, that benefits from the attestations not from the counties not being published are the people who are refusing to communicate at all. Those are the only beneficiaries of that. Tenants who need help, first of all, I want to make sure it's clear, I want tenants to get help. This has been a really hard time for economically for everyone. And so these programs are intended to provide access to resources, and tenants always have the ability to contact their local dispute resolution center or the programs that the county has posted on their websites to apply for help. So hopefully where this goes is we continue to make sure that the counties are doing what they are obligated to do to get tenants who need it access to financial help.
Why would King County be so slow to distribute their money? Is it just an administrative issue, or is that just, we don't want to go down that rabbit hole? But
I don't think you want to go down that rabbit hole. I think that there's a lot of dispute about that. But I would argue that there's a lot of money there. They have access to a lot of funds. If I were a tenant personally, I'd be very angry that they've only distributed 4% of the funds that they have access to.
Crazy.
That means that they're basically willfully withholding access to funds to people who need it. And for what reason? I can't think of. They're one of them. I would say King County is it is the largest county, or at least most populous, I believe. And they have the most tools in their toolbox to make this work. So they should be setting the example in the way of getting funds out to people who need it. And one of the big issues that I take is that some of the funds that the counties have access to are federal funds. And these federal funds, they have strings attached and they expire. So the longer that the counties sit on these funds, the more likely it is that the funds will expire before they can get them out to the people.
Nuts. Okay, we're going to skip that rabbit hole. But
Yes.
I might have some ideas to try and, talk about that topic further, but we'll move on.
Right. Okay. So let's move on. I'll go to my next slide. We went into a little bit about the rentalist distribution of HB 1368. And if I remember correctly, this was the bill that was passed that had funds allocated directly for landlords to access in the situation where a tenant was, not responsive at all, didn't want to participate in finding access to public funds for rent that they'd become, behind. However, on the governor's desk, when it was signed, he line item vetoed any of the funds that were directly accessible to landlords. So I think that's this bill where that happened. But it allocates the money to each county and also created the Landlord Mitigation Fund, or at least it increased it. So some investors or landlords or individuals who provide housing may remember that there used to be a $5,000 limit on some funds for landlords who do things like provide low-income housing that maybe doesn't meet the standard of the high standards that maybe like the city of Seattle or the state require when you're providing low-income housing with regard to health and safety. So maybe there's some upgrades that are required. Well, that fund was initially built to provide the landlord with some money to get the property up to snuff in order to then provide the housing, the low-income housing, and also provide some insurance against damage to the property down the line. That what they did was they took this fund and they expanded it a lot. And so it's now up to $15,000 that a landlord can actually make a claim for in unpaid rent between what we've called the protected dates, which is the end of the 20-19.6 eviction moratorium, which expired June 30th, 2021, and 6 months after, which would be the end of this year. So December 31st, those are what we're calling the protected dates. So if in some situations, a landlord enters into a reasonable repayment plan with a tenant regarding unpaid rent in that timeline, and the tenant does not perform, the landlord, under certain circumstances, can actually just take that payment plan proof to the Department of Revenue in the state of Washington. And the Department of Revenue may provide up to $15,000 in unpaid rent to the landlord directly.
So that was this year, June 30th, this year or last year?
No, this is active right now.
Okay.
So this, I think the access to these funds started during the protected dates, which technically is actually March 20th of 2020 through December 31st of 2021. So if you had rent that accrued during that time frame, you may have access to these funds, to the Landlord Mitigation Fund. But it doesn't really, I think there's a lot of strings that are attached to it that are worth, considering. One of which is if the tenant was actually evicted for another reason. So let's say they had a behavioral issue that created a significant health and safety risk to themselves or others. And so you ended up having to evict that person. They may deny you access to these funds for that. So you'd have to basically just go after the tenant directly, which obviously we know causes its own problems.
I'm making little side notes that people need to follow up on after this show. One being check Snohomish County to see if you can evict up there. Number two, check the Landlord Mitigation Fund that is still available apparently through the end of this year, on follow up and get the details on if that's something that you can, recover some funds from on these protected dates. Kind of little bullet point stuff, Joe, bullet point stuff.
And I can actually provide access to a public website that was created by the state of Washington that tracks that information for us. So it lays out live, what counties have published their judicial order regarding the eviction process. And also which local dispute resolution centers have actually attested that they are up and running. It's basically a Google Live spreadsheet that the state is keeping to help streamline all this information.
Do you have something for the Landlord Mitigation Fund, like somewhere where people can go link to that or find that?
Yeah, I will make a note. It's through the Department of Commerce in Washington State, and I do have a link to that, so I can post that later or just email it to you guys directly. And it's worth noting that website will have actually 3 different types of funds that a landlord could potentially apply for depending on their certain circumstances. So I will give you both links to each of those 3 funds so that each landlord can see what category they fit into. And then the specific one that I'm talking about, where it's basically just non-payment of rent for up to $15,000. Because obviously landlords are dealing with damage to the property as well as non-payment of rent. And those funds are treated differently. So
awesome.
In some circumstances, I believe that some landlords have been able to access an additional $5,000 for damage. So it just depends.
So if you guys are paying attention or you're only slightly paying attention, you guys can hit me up. You can find me easily on Facebook if you feel like you need help or can't find these links. And I can get them to you, as well as we'll post them on the Seattle Investors Club site and in the show notes here as well. So just stay in contact with us, peeps. We are going to be your resource and also a lifeline to Kaitlyn as needed.
Right. Okay. So now I want to touch base on HB 1236 with the just cause, statewide just cause ordinance. And I believe if many of you guys are Seattle investors, you're very familiar with what just cause means. But essentially, if you're not, it means that in order to terminate or cease to continue a tenancy statewide, you have to have some just cause or reason that the state has approved or put into this law for doing so. So, for example, some of the rules are if you're in a month-to-month tenancy with a tenant and you want to sell the property, that is one of the just cause reasons why you can terminate that tenancy, but you have to give 90 days notice.
Is 90 days the statewide then?
Yeah. 90 days is the statewide. And so for those cities that had previously or during the moratorium provided something like 60 days notice for that sort of termination, it's basically overridden. Whatever is more beneficial to the tenant is what will govern the law.
Do you know if there's any counties that are longer than 90 days?
For selling? I think that there is one county out there, I think Federal Way or City. I don't quote me on this because I don't have them all memorized. I actually have to keep spreadsheets for this because my brain will melt. But I think Federal Way may require 120 days for most reasons. That
would be really good to verify for us if you want to make a little side note, because
verify.
A lot of people that are interested in rentals and have rentals in Federal Way.
Yeah. Federal Way has an ordinance. I think it's called Safe and Secure Housing or something like that. That definitely provides a lot of extra protection for tenants who are month to month. So that's one reason. If you're going to have but I should note that statewide, the rule is that you can only terminate a month-to-month tenancy for the reason that you're going to sell the property if it's a single family home. You cannot terminate month-to-month tenancies in the state of Washington for the reason that you're going to sell if it is a multi-family property or an apartment building.
Well, which is less of an issue because people sell with tenants in place.
Exactly. Yes, especially because the point is investment, and having tenants in there is a good thing usually. And then another reason would be something like if you are going to have an immediate family member, yourself or an immediate family member, move back into the property. That's also a 90-day notice. And I'll go over some more specifics on these reasons, but I'm going to try to hit the point that many landlords or property owners were trying to use the governor's 20-19.6 proclamation, which required 60 days notice to terminate for those reasons. Actually, when this law came out in April, it basically overrode any of those notices. At least that's the way that the courts have been ruling on this issue, is basically if you had a 60-day notice that was out, that complied with the governor's proclamation, then this law was passed that basically you needed to start over and provide a 90-day notice. So if I don't think anybody's left. I mean, there's very few, but back in May and June and July, this was definitely an issue coming up pretty regularly. Hopefully now that we're in September, it is not. And most individuals have actually resolved those cases.
Let me ask you a little detailed question on that. So if we have to give, let's just 90 days notice, everybody. Now, does it matter what day of the month? Is there a calendar month thing? Like you got to give it on the 1st, or can you give it on the 15th and the 90 days just runs when 90 days is from when you give them the notice? That's a little detail point.
That's a really good question. And it does come up quite a bit. It doesn't matter what day you give it. It matters what day it expires. It must expire at the end of a monthly rental period. So if rent is due on the 1st, it must expire at the end of that month. So the 30th or a 31st, depending on that.
That means that it's going to be within 1 or 2 days of a calendar month, or you're going to have some extra time at the end, right?
Right, exactly. So you're going to be in a situation where you're giving at least 90 days, remember? So if you give it on the 15th of the month, they get, the full 3 months and the end of the next month. So
super big detail point, people.
Yeah.
That is your nugget right there.
I think that the hypothetical would be today is September 7th. So if I decided to give a 90-day notice, it would not expire until, let's see, end of October, November, until the end of December. Basically, September wouldn't count. At least the remainder of September wouldn't count. The rule would have been if I had gotten it out on the 1st of September, however, at least 90 days. And thankfully there's 31 days in October. It would expire at the end of November.
There you go. That's a really big point right there that people mess up. So that's gold nugget on that one.
Right. And that's one of the first things I look at when somebody brings a hey, I provided notice to my tenant, and I'm like, well, what does your lease say? What's the first day that rent is due? And if it says the 15th and they provided on the 1st, then I have to give them the bad news, especially since the notice itself has to actually state what day it expires. So if you've done the math wrong or put that information in there incorrectly, you have to redo the notice.
Oh, that's what I was going to add layer on top. So if you screw this up, you have to start over.
Yep.
So, and it has to have the date on it of the last day of the month.
Right. Or, I wouldn't say last day of the month.
Last day of the rental.
Last day of the monthly rental period. So if your rent is due on the 15th, you know that your rental period is through the eve of the 14th, the night before the next month. So
huge, big deal. Yeah. Must expire in the written notice on the last day of the rental period.
Right.
Okay, guys, you've been told now. Don't mess it up.
Hey guys, it's Julie here with a quick break from the show to discuss an opportunity some of you may have interest in, which is to work more closely with me. On almost a daily basis, I get calls from investors and brokers, both new and experienced, asking me for guidance or advice. I love helping you guys out, and it keeps me on my toes too. So with that said, I wanted to let you know that I have a private broker coaching community called the VIP Education Community. And the best part is that it's 100% free. That's right, it's free to join. So whether you're a traditional broker or a broker investor, my VIP education community offers personalized one-on-one coaching from not just me, but also from my experienced broker friends with expertise in all disciplines of real estate and real estate investing. We'll teach and share our modern marketing strategies, our tech and lead generation resources, plus teach you how to identify or offer up opportunities for yourself or for your clients using techniques such as seller financing, lease options, land entitlement deals, BRRRR investing, flipping, multifamily or commercial coaching, whatever you like. We've got it all covered for you. The future of real estate is changing fast, and to stay in the game, it's time to learn about all the options you can offer your buyer and seller clients, as well as, if you want, learn how to use those skills to grow your own real estate portfolio. If you'd like more details about joining my VIP education community, reach out to me at julie@seattleinvestorsclub.com or text me at 206-910-2985 or just send me a Facebook message. My new favorite phrase is community equals confidence. So let's navigate the future of real estate together. Now, back to the show.
Okay, so I would like to move on to the just cause exemptions. So there are some situations that are exempted from the just cause ordinance. We did our best. This law, if you've taken a chance to peruse it, and hopefully not because it'll drive you crazy. This is the simplest diagram that we could come up with after a long, long time trying to organize it. But essentially what it says is that you have the right to terminate a term lease, not early, but essentially at the end of a lease agreement, if you meet certain requirements, because some of the laws and the just cause may even force you, and you might want to look at your cities as well, say that there's an obligation to renew lease agreements or not, or if they are a term lease under certain circumstances. So
is Seattle the only one right now that might have that, or is there more?
I think Federal Way may have that as well. Yeah. And I think if Burien hasn't done it, they're going to do it. So it's kind of creeping in city by city that you'll have basically a mandatory lease renewal provision. But where I think people need to be aware and just really remember is that there's no longer an assumption that if you have a lease term, that it terminates on the expiration of the lease automatically. That should not be your assumption anymore. You may be sort of required to continue that lease agreement for, on a month-to-month basis thereafter, unless you meet certain requirements, which I'll go over, or in some circumstances, a complete renewal, which would mean if it was a year lease, you have to give another year lease under certain circumstances. So this would be under, 1236. And I think this is actually last week, I think they finally codified it in RCW 5918, which many of you may know is the statewide landlord tenant statute. So you may look there as well for this information. But so these exemptions are a couple things. One is if the initial lease agreement is a fixed term between 6 and 12 months, and it converts to a month to month at the end of that term. So your lease actually says after there, which, month to month. If the tenancy does not continue, let me restate that. The agreement continues past the initial term and converts to month, then your just cause ordinance will apply. So basically, if you've checked that box or you have that language in your term lease agreement that says it goes month to month after, you cannot terminate that, or the lease does not terminate at the end of that initial term unless you have a just cause reason. So hypothetical here, if I have an 8-month term lease with a tenant and it says month to month thereafter, for some reason I checked that box or wrote that in there, I can terminate that tenancy at the end of the 8 months if I provide 90 days notice that I intend to sell the property and it's a single family property. So basically I have to find one of those reasons that are in the law and provide the requisite notice before the expiration of that lease term in order for it to end at the expiration of the term.
Right.
Okay. So if the initial agreement is a term of 6 months or more that does not convert month to month, the agreement is allowed to continue month to month or a term less than 6 months at any point, then just cause will apply. So if you have an initial lease term that's 6 months and it says in there that it shall not continue month to month thereafter, or it expires, whatever language you've put in there, if at any point, before that lease was, or there was some sort of, break in the term and it went month to month for a month, at any point prior, then just cause will apply. So that's kind of for those situations where maybe you've had a tenant for 2 or 3 years and you were on a term lease, it expired, and then you went month to month for a while, and then you decided to put them back on another term lease or something like that. Then if that's the point where just cause will apply in order to have to terminate that lease at its expiration. However, if the agreement was continuously renewed for a fixed term of 6 months or more, you may end the tenancy with no cause with 60 days notice prior to the end of any specified term. So let's say I enter into a 6-month lease agreement with a tenant, and it says in the agreement very clearly that the agreement does not renew or does not go month to month thereafter, and I give another 6-month extension, then I can terminate for no cause at the expiration of that second extension. However, I have to give 60 days notice before the expiration of that second term that I am not going to continue that agreement.
Do you have to offer the second term?
Yeah.
So you have to offer the second term, and the 60 days kicks in only if your original lease stated that there's no month to month, or that it expires and you didn't screw up and forget to do your paperwork and get it done on time. So they actually ended up 1 month, month to month. If you don't do it on timely about this, you go to just cause, which is the 90 days. If you
not 90 days, just cause, full stop. You may, you don't have any of the reasons, you can't terminate.
Right. So. Okay. Gotcha. You have to go with just cause. But if you don't actually have to use just cause if you have your lease that says it shall not continue and that it expires, and you are on time with your renewal for the second term, right? Mm-hmm. Mm-hmm. Then it is okay then to time it that you can give 60 days notice during that second term without any just cause. Just for any reason, you can give notice.
Right. So basically, as long as you have shown that you've provided an initial term of 6 months, and then there's been at least another 6-month extension, now before the expiration of the extension, 60 days notice before, you can say this is deemed expired. And I think the language in the notice has to say your lease is going to be terminated at the expiration date, right? Gotcha. That is in the lease agreement, and it is deemed expired. I think that's like one of those little nuggets of information that people will have to remember, it says it has to say that specific language.
It is deemed expired.
Yes.
Don't try to do this on your own, guys. But let me just reiterate something. Let me ask a detailed question. If your initial term was 6 months and your lease says it shall not continue and it expires, okay, now you're pushed into, you have to go to your second term. Your initial term was 6 months. Do you have to match the term? So I have to do 6 months, or could I do 3 months and after 30 days give my 60 days notice?
No, it said the language in the law says the agreement must have continuously renewed for a fixed term of 6 months or more. Okay. So if you do start with a 6 month and then you try to renew for another 3, that will put you into just cause.
Got it. But if you started with 12 months and then you go 6 months, because that's the minimum, then you have the opportunity to stay within these timelines to use the 60 days notice.
Well, that's a different scenario. So that's a different scenario under the law, because the law separates 6 month agreements that are, renewed continuously with an initial agreement that started as 12 months. So let's get into that. Like I said, it's literally the most confusing hodgepodge language of, depending on how many months you started with, was it an initial term? All of these things have a different result. So,
but where we're at right now is if you had a 6 months term and you renewed for the second 6 months on time, because 6 months would be the minimum, and you had no break, and your lease stated it shall not continue month to month, and it expires, or it's deemed expired, you can go 6 months, another 6 months, because that's the minimum. And within those 6 months, you can give 60 days notice, and you can terminate the lease without invoking just cause.
Correct.
All right. Okay. Now we're going to move on.
Good.
We're going to move on to
now we're moving into, if your initial agreement is for a term of 12 months or more, which does not convert month to month. So if it does not convert month to month, if you renew that agreement for any period of time thereafter, as long as you can provide that 60 days notice prior to the expiration of that thereafter term, you are not subject to just cause. So hypothetical, if I get into an initial lease term with someone for 12 months, and then they ask me for an extension for 3 months because they are going to buy their own property, so long as I can give that renewal for 3 months, as long as there's no break between those two timelines, and 60 days prior to the expiration of the 3 month, I can give my notice of non-renewal, deemed expired, et cetera, et cetera. At least that's my understanding of the law, though I will
Excuse me for a second, because you said that they ask. That mean that the tenant asks.
Oh, I'm just saying hypothetically, this is how I see the scenario happen, right? I think most landlords want to keep bodies in their buildings. So usually they're asking for another renewal of 12 months, right? So in those scenarios, that's the scenario where the landlord comes to me and says, well, what if they're asking me for just 3 months? Do I have to give it, or how does this work? Well, if they ask for 3 months, or you want to do 3 months for some reason, as long as your initial agreement was for 12 months or more, and the agreement specifically said that it does not convert month to month thereafter, and there's no break, you can do a 3 month extension, and then 60 days prior without just cause.
Okay. So in a nutshell, there's a 6 month minimum on the renewal. A way to have that be lower than the 6 month minimum on renewal is if the tenant asks for a short term. No,
sorry. No, it all depends on what your initial lease term was. Was your initial lease term for 6 months, or was it for 12 months? That's how the legislature has divided it, is they've decided that for some reason, if you've given them 12 months in the property, you have the ability to extend it for shorter periods of time than 6 months.
It's like a bonus. It's an incentive to have an initial 12-month lease.
That's exactly right.
You only can have the flexibility of the 3 month term requested by the tenant if you initially gave a 12-month lease.
Right. And it doesn't have to be requested by the tenant, as I understand it. It could be the landlord. But my experience is generally that usually the landlord's saying, hey, you want another lease of 12 months. They don't usually want a lease of 3 months. So that's the scenario that I see being most common. So yeah, you get sort of a bonus of extra rights and extra protections if you have an initial agreement with the tenant for 12 months or more. And so long as it doesn't say it converts month to month. So if the agreement itself says that it converts month to month, then if that agreement allowed to continue for month to month at any point, then just cause will apply. So I'm encouraging my clients to make sure that any agreements they're writing are for 12 months or more, and specifically state that they do not go month to month thereafter, and making sure that they have it calendared, in their system. If they're not planning on renewing that lease again, at least 60 days to send out that notice that the lease is deemed expired. So
if you're on a 12-month lease, but if you're on a 6-month lease, you need at least 90 days. Or
no, I mean, that's only if you're going to do a just cause termination, right?
Right.
Yeah, right. And so if you're on a 6-month lease, then you need to make sure that you renew it for at least 6 months and don't allow it to go month to month at all. In the interim. And we can talk very briefly on Section K of this provision. I believe if I have this memorized, says that if you offer at least 30 days in advance to the expiration of a lease term, if you offer a reasonable lease extension. So if I have a 6-month lease with somebody and it's for $1,200 a month and it expires in, let's say December. So at least 30 days in advance, if I offer them a renewal and they don't elect to take it and all the terms of the renewal were reasonable, then the lease may expire, whatever it is, 6 months, 12 months or whatever. The issue there is that any rent increase requires 60 days notice. So most landlords need to be aware that if you're going to offer a tenant reasonable lease terms for a renewal and it includes a rent increase, you need to be doing that at least 60 days in advance. So hypothetically speaking, if I have a tenant that is got an initial lease term of 6 months, well, 4 months before, if I want to raise the rent and I want to offer them a renewal of 6 more months and use, hopefully have the protections of that section, should the tenant decide not to accept the reasonable terms, then I need to make sure I'm providing 60 days notice if it includes a rent increase.
Okay.
Is your head spinning yet?
Yeah, this is hugely important. So even though we might not get through all the slides, these are the meaty things, right?
Yes, this is the meaty stuff.
This is the meaty stuff. So rent increase again. So let's go back to, now I'm getting totally clustered F here in my head. So
I know how you feel.
When can you give a rent increase? Let me back it up. Does the term of the lease matter, 6 or whatever? So
no.
Initial 6-month lease term, you have to give another, renewal on a lease term. If you start with a 6-month lease and you want to give a rent increase in the second term that you're required to have, you can do that.
Yep.
With 60 days notice, right? But that notice again is going to have it has to be on the 1st or something, right?
Yep.
Otherwise it could be longer than 60 days like we talked about before. Okay. So if they say, no, I don't accept that. You can't, what if they just say no? And then you can't evict them.
You can. So technically that's what Section K says. If you offer a reasonable lease term, at least 30 days in advance, right? And I'm going to say 30/60, because if those quote unquote reasonable terms include a rent increase, it will not be reasonable if you don't give the proper 60 days advance notice of a rent increase. So if you offer reasonable lease terms within that time period required and they do not accept those terms, then just cause does not apply to you and that lease agreement expires when it's supposed to expire.
Wait a minute. Now, is that a slight loophole?
I would not call it a loophole. I would call it a protection for landlords and
there's
for tenants.
The landlord part.
Hmm?
There's the landlord's protection, I guess I'll say, of this part.
Right. So for example, if I have lots of situations, as you guys probably all know, property taxes are increasing regularly and sometimes significantly. So if property taxes have increased and you need to spread that amongst your tenants, then 60 days in advance of an expiration of a lease, you may need to allocate those increases to a tenancy or to a rental agreement. That's reasonable. That's exactly reasonable.
So you're saying to underscore the definition of reasonableness, it might not be a bad idea to be able to have a reason and a story of how you've come up with this rent increase, such as spreading your property tax increase across.
Yeah, exactly.
Or it could be that you had to replace the roof.
Exactly. Yeah. I mean, that's the when there's a word in a statute like reasonable, it's somewhere for the parties to create an argument, right? And so if there's an argument created, then there's going to be there could be a lawsuit. And if there's a lawsuit, a judge is going to have to rule on, or a jury, hopefully just a judge, not a jury, would rule on whether or not you were reasonable and whether you complied with the law. Once again, I want to keep your file off my desk. So my, general advice is to make sure you have documentation as to the reason why you are increasing rent and and justifying that amount. And I wouldn't say that you need to go straight to this state law, because many counties and cities are also, putting statutory limitations on what you can raise and the timeline required by it. So for example, if you look at King County, they passed, for the unincorporated portions, significantly different timelines if you were increasing rent, between 0 and 5% or more than 10%. So if King County requires 120 days notice of a rent increase for a property, if you're going to raise it more than 10%, then by statute, you can't, if you're going to give them 60 days notice of that, 60 days notice of that, or 30 days notice of that, you're going to find yourself out of compliance with a county ordinance, even if you are in compliance with a state law. So these are very detailed considerations. And so you want to be very careful about how you go about them.
Yeah. You have to track all that on your own, right? Because there's no one place to look for this. The rules on which cities require how much notice based on the percentage of your rent increase. Like Seattle used to be, if you're going to increase it, 10% or more than 10%, it was 60 days, right?
Right.
What is it now? Do we know?
Well, I actually don't know off the top of my head. I don't know. I think that's still technically the rule, but I don't think, can you even do rent increases in Seattle right now? Seattle has their own ordinances on eviction and on rent increases that are for the emergency provisions, which I just don't have memorized. But if you want to find out more details about those things, the class with RHA tomorrow is about Seattle specific ordinances.
Gotcha.
And that would be an interesting class, because I'm with the state laws alone and the county laws alone. I'm trying not to memorize all of these things, because there will be no room left in my brain for anything.
And they change. So guys, if you're listening to this, that meeting has already occurred. And the best way to not miss stuff like that going forward is to stay plugged into Seattle Investors Club on our Facebook page. I don't know, Kaitlyn, if we can establish something where you might give me a heads up in the future when there are big meetings like that we can send people to. I mean, I guess everybody should just join RHA and it's probably all right there.
It is. Yeah.
Right?
Yeah. And I'm obviously a member of RHA, but that's through the nature of the fact that I'm also a landlord, and I find I participate as an educator, but there's so much information out there right now that I don't see one person being capable of understanding all the statewide laws and rules and all the cities and the city ordinances and county ordinances on your own. So I like the idea of being part of a team so that I know who the go-to is for Seattle questions or for Bellingham questions.
You know what costs you more, guys, than a legal bill to help make sure you get this right? Is you wasting your time and having to start over with a problem and having to refresh the button for 90 days. So, I'm just putting my 2 cents out there. Get the help.
I have quite a few cases like that right now. And I will tell you that the tenants, if they were paying before, a lot of times are not motivated to pay after they've received a notice, because remember, some of the landlord mitigation funds right now are only if you keep the tenant. So if they know they're getting evicted, they know that your only way to try to collect these unpaid amounts is to pursue them personally later down the line. And I don't know if any of you have ever heard about trying to squeeze blood from a turnip.
Right.
But it's not a fun endeavor. So
Great point there. That some of these funds are only going to be there if you're tenant. And yeah, exactly. That makes a valid point. All right.
Okay. So I'm going to move on to one more meaty portion of this provision, because there's only about 23 days left to take advantage of it. There is a safe harbor adjustment window between May 10th, 2021 and September 30th, 2021. So 23 more days. You will notice if you look at the slide.
What was that end date? My cat jumped in.
September 30th, this month. Okay. End of this month.
Oh, geez. Okay, Joe, we got to put the word out.
Yeah. So basically, if you've read all of this initial, this exemption for just cause, all the lease terms, it always says initial agreement. That is a magic language, right? So if you're talking, these requirements have to be starting from the initial agreement between you and the tenant. So during the moratorium, many tenancies that would not have normally gone month to month went month to month, because landlords were prohibited from terminating any tenancies. So if you were prohibited from terminating them, you certainly didn't have a reason to offer a term renewal. You just let the lease continue as it was, because you couldn't raise rent, you couldn't terminate, you could do nothing, right? So the legislature created this little, what we're calling a safe harbor during this time period, where if you enter into a tenancy, or a tenancy that was had indefinite in the existence of the effective date of the section. So if it was month to month, as of May 10th, 2021, if the landlord and tenant enter into a rental agreement before September 30th of 2021, that fits, it's a 6 month, it's at least a 6 month term, then you are considering the legislature will consider that agreement to be the initial agreement. So you don't have to worry about any of these little loopholes or bullet points that said, but it has to have never been month to month prior to this in order to get this protection as a landlord. You don't have to worry about that. If you enter into a lease agreement, a term lease agreement of 6 months or more before September 30th with that tenant, if they were month to month as of May 10th, 2021, it will be considered the initial agreement.
Let me go back to, but it could never have been month to month prior to this. Well,
no, so you get to ignore that in the law, basically. That's what they're saying is if it was month to month as of May 10th, 2021, for any reason, pretty much whatsoever, if you get the tenant to sign a 6 month agreement or more than a 6 month agreement, it is treated legally as the initial term. So everywhere.
Yeah. So everybody needs to get on it.
Yes. The tenant is not required to sign any of these leases. So even if you say, hey, I'm going to, give you a 12-month lease and I'm going to promise not, obviously there's no rent increase, whatever strings you can attach to it to benefit them. If they don't want to sign it, they don't have to sign it. There's no way to force them to do it. So if you want that treatment, you have to make it very, very tempting for the tenant to sign it. Otherwise, the tenant will have just cause protections. The problem and the question that I get the most often right here is, well, what if your lease term went month to month in June of 2021? Technically, you can't access the safe harbor and you're stuck with just cause.
Wait a minute. If it went in June 2021, the safe harbor started May 10th, 2021.
No, so if it cuts off at May 10th, so it requires that the lease agreement have basically fallen into month to month prior to May 10th, or I guess I should say May 11th. If it fell into month to month after that point, you're technically not protected by this safe harbor. The problem I had with that was that the Proclamation 20-19.6 was in full force and effect through June 30th. So many landlords weren't even aware, if their tenancy terminated as of June 1, which was pretty common because that's the first month of sort of the summer months. That's when many lease agreements, in my experience, naturally expire. Those landlords do not get that protection or may not make a claim for that protection. Now, this has not been litigated yet, so we'll see.
We need to put the word out to all our friends that if they have been on a month-to-month lease prior to May 10th, that they need to re-up a lease if they can by the end of this month to enact the safe harbor stuff that will put them in more of a control position to manage their lease going forward with some benefits versus the worst case scenario.
Correct.
Okay,
moving on from that. That was the last part of that meaty section, thankfully. This slide that I have that I will share with you guys is a more detailed explanation of the safe harbor window, but we went over that as much as we could. This other slide is the main different just causes in their timelines. So you still have the 3-day notice to terminate if a tenant's causing waste, nuisance, or unlawful activity and unreasonable interference with the enjoyment of the premises. You still have access to the 10-day notice to terminate if a tenant fails to comply with a material term of the rental agreement within 10 days of receiving a notice to comply or vacate. One thing I want to hit on that is that provision or that law regarding 10-day notices has changed significantly. So if you're a very familiar landlord with 10-day notices, you want to make sure you read it and update your forms, because there is now additional required language to go in those forms for certain types of termination for under 10 days. For example, the material language, it has to be a material lease term. If you're going to avail yourself of some protections where if you have to give 10-day notices more than like 4 times in a 12-month period, there's additional language you need to put in each notice. The other thing I want to just
What's the definition of material? It used to be 10-day pay or vacate. What's material?
You mean 10-day comply or vacate. And well, I think there is a definition of material, but here's the easy way I put it, is I tell my tenants or my clients to put that all rules of the lease agreement are material. Just like that's right. Because what you're asking is what we would call an issue that if the tenant argues it, you're going to end up in front of a judge. Hey, judge, is this considered a material? You don't want to be there.
Is this another loophole by chance? Like
for whom?
For the landlord to make an attempt to, if they've got the right definition of material communicated, that there's non-compliance with, part of that could be paying the rent, or is that then gets
no. These types of 10-day notices are totally non-monetary. These are behavioral things. These are things like the tenant has a pet that is not allowed, and they haven't followed the ESA protocols or something of the sort. Or what I find most common is when the tenant lives in an HOA environment and the tenant is not complying with the HOA rules.
Right.
That's a 10-day comply or vacate. But you want to make sure that you've brushed up on that language of that provision, because there's new language that you want to make sure you have in there, and you want to make sure that you understand that it's got to be material. And then there's also now a private right of action created for tenants if a landlord does not put all the material information in these types of notices, and the tenant is evicted based on, that information, the tenant can come back later and sue the landlord for damages. So making sure you thoroughly understand everything that needs to be in that notice is really critical if you're going to use that.
Sounds like you guys need some advice from an attorney for that. That's what it sounds like to me.
Just be careful. Just make sure that's right. Talk to an attorney, or at least really make sure you've read the law and you really understand it. Okay, so then we can't do this yet, but at some point, one of the reasons you can is a 14-day notice to pay rent or vacate. This is not, you can't do this right now, obviously. In many counties, you have to go through the dispute resolution center first, the eviction resolution program. But hopefully at some point in the future, this will be back in action. Then there's the exception of 20 days notice if you're going to terminate a tenancy. If the owner or the lessor shares a dwelling unit with the tenant, you do not need any cause. You just need to give 20 days notice. And so that's something to just pay attention to. That law, is, you want to make sure that you have a lot of evidence that you share common areas. I will just make that side.
So if you are of the model of some people that do the boarding house style or rent by the room and you actually live there, this is you.
Right. Correct. And then if the tenant commits acts of sexual harassment directed at housing providers or another tenant based on the person's race, gender, or other protected status in violation of any covenant or term in the lease, you can give 20 days notice. I find it very fascinating that if you're causing waste, nuisance, or unlawful activity or an unreasonable interference with the enjoyment of the premises, that you only need to give 3 days notice. But if you're just sexually harassing somebody, you get more time.
Right. Please.
I love our legislators. So 30 days notice, if the premises is condemned and continued habitation would subject the housing provider to civil or criminal penalties, you give 30 days notice. However, I will point out that provision also requires that you pay, there's provisions that require the landlord to pay relocation assistance and potentially attorney's fees and actual damages. So be very wary about that procedure. It's not just as simple as 30 days notice, get out. It's maybe 30 days notice, get out. And also I'm going to have to write you a very large check. So be wary. If the tenant is no longer eligible for a transitional housing program, 30 days notice. Tenant fails to sign a new rental agreement.
What does that mean? They lose their Section 8 housing?
Transitional housing program, I think, is more of the if you're getting out of prison or jail and you need transitional housing for that process. That's one of those definitions. Or I think some of them are for drug and alcohol rehabilitation center, transitional housing programs. And I don't think I consider Section 8 to be transitional housing. I think there's all sorts of transitional housing programs. And maybe this is a good conversation with regard to a lot of, refugees coming from Afghanistan are probably looking for transitional housing. And this may be one of those programs that would get this protection, or those programs may be protected under, with the 30 days notice if they have certain requirements for those individuals and they're no longer eligible for any reason. I don't know, that would be very, very fact specific in my opinion. And then this is Section K, which I went over before. If the tenant fails to sign a rental agreement with reasonable terms offered at least 30 days prior to the expiration of the current term rental agreement, well, that's the 30 days notice right there that they get. And you want to make sure that your 30 days says, here's the reasonable lease terms. If you do not accept by this date, this is your notice to terminate. You want to make sure that you break that out into two separate issues. If you just offer and then they don't accept, then there's nothing in there about what the consequences are of their failure to accept, then you might get stuck into a month-to-month and then subject to just cause. Intentional, knowing, and material misrepresentation or omissions made on the tenant's application that would have led to an adverse action, you can terminate with 30 days. And if the tenant vacates, leaving other occupants behind, You can serve on those occupants a notice to apply to become a party to the rental agreement or vacate within 30 days notice. That one's tricky. That one's really tricky right now. So if there are other occupants, you don't necessarily have the right to simply say, other occupants, you're unauthorized to be here, get out. If under many circumstances, you may have to offer that they become, that they apply to become a party to the rental agreement. Or if they don't, then they have to vacate. So moving into the 60 days notice section, other good cause constituting a legitimate economic or business reason. So basically you can give 60 days notice if you have other good cause constituting a legitimate economic or business reason. I don't even want to know what that means. I don't want to be case law. So that's totally new. I believe there's some sort of federal definition out there that may be used as guidance to judges who are asked to determine whether or not the other good cause fits this definition. You don't want to be that person. So I encourage you not to. But I suppose if you really do have a really good business reason why you'd need to terminate with 60 days notice, talk to an attorney, get all your facts in order, and see if you can take a swing at this reason. If the tenant is required to register as a sex offender during tenancy, or if they failed to disclose that, if it was required at the beginning of the tenancy, they get 60 days notice.
Right.
That is still so absolutely out of this world to me. That if you actually commit acts of sexual harassment, you get 20 days. But if you're committing waste or if you leave your garbage out consistently over and over again, and it creates, maybe somebody knocks it over and there's rats everywhere, you get a 3-day notice for that.
Right.
But if I don't know where they came up with these numbers, these reasons. I'd love to sit down with the people who made that decision and be like, so please explain this to me. Why does this person get 60 days? But that's true. So if the tenant commits 4 or more substantial violations in a 12-month period, each leading to the housing provider to properly serve a 10-day complier notice to vacate, you can give them 60 days notice that you're terminating their tenancy. Or that their tenancy will not renew. You can't terminate a term lease, but you can terminate it month to month or refuse to renew it at the end if that's your reasons. If that's your reasons, and you have to. That is where I was pointing at that 10 days before, where there's new language. You want to make sure you have that information if you're doing a 10-day notice, so that you can preserve your right to use this section if you need to. The last few sections are basically if the 90-day notice requirements are if there's the owner or immediate family member needs to occupy the unit and no substantially equivalent unit is available in the same building. And there's a requirement that if the owner or family member does not occupy the unit for at least 60 of the 90 days immediately after the tenant vacates, then there's the presumption that the landlord did not comply with this provision. So you're basically opening yourself up to a lawsuit. So make sure that if you're going to use this, you use it properly and make sure that the owner or the family member actually lives there for 60 of the 90 days immediately thereafter. The biggest question that I get is, well, what if I need to make repairs or maintenance? Well, that's going to depend on things like, did you know about these repairs before you issued the notice, or how substantial were those repairs? Would it have really stopped you from living there? Those are all fact specific. These are the 60 consecutive days during the 90 days immediately thereafter requirement is really just a presumption. So you'd have to have evidence to present it to overcome the presumption that you were somehow wrongfully using this 90-day notice. And then if the owner elects to sell a single family residence, the owner must make reasonable attempts to sell within 30 days of the tenant vacating. So that's also one of those ones that comes up. Well, what if I have to make repairs or I'm going to do improvements? Once again, these are presumptions. You just have to come up with really good evidence to overcome those presumptions. You will notice that the 120, there's a just cause requires 120 days if you elect to demolish or substantially rehabilitate the property, change its use, or if you're changing its use, like converting apartments to condominiums. If you know that the property needs substantial rehabilitation before you're going to sell it, I would advise you to give the full 120 days notice so that you don't have to worry about this presumption later that, you only gave them 90 days because you were going to sell it, but really you were going to demolish or you were going to substantially rehabilitate it first before selling it. So I would use the 120 just to stay off my desk. That's it.
Right.
The other local just cause, Seattle, Burien, Federal Way, Auburn, there's a bunch of them. Remember, if they have more strict requirements in any of these areas, that is what is going to apply to your lease agreement, or to your behavior as a landlord. I would really like to see, way I try to advise clients is like, the city council has more power over these decisions or over your property than you realize. So being active with your city council and making sure that your voice is heard with regard to these issues is incredibly important. It's hard for the state legislators to actually create new good law. It takes a lot of work for them. It is much easier for a local city council member to do just as much, and I will use the word loosely, but damage. And they have a lot more ability to and they have a lot less resources to really thoroughly investigate whether or not the protections they're thinking of passing actually are effective or what other unintended consequences those things have. They don't have the funding available to do all the research or get, lobbyists to come in and explain to them unintended consequences. They don't have that. They just have basically meetings where they bounce ideas off each other. And here you are now, you're stuck in a situation where you have 120 days notice rather than 30.
Word. This is who's all sweating besides me. I'm sweating over here listening to all this stuff. The thing is, though, it's the fact that we have the information here kind of puts it on us it's kind of like there's a path, guys. And if there's a path, then, it's on you to use the proper path, right?
Right. And we did not go over or have not gone over the dispute, the 5160 rules for going through the dispute resolution center to evict for non-payment of rent. We went over that in the beginning, that most places you still can't do that. I think that could be reserved for another day, for another podcast.
Can we rebook another one with you?
I would love to.
Okay, let's do that.
Especially since I'm still learning about it, because there's just as many questions as that I have that haven't been answered yet.
What is that topic? And we'll get something on the books with you like 30 days out for you to school.
I think that's a good plan. The current moratorium that the governor's office, we'll call it the bridge proclamation that's in place, where the governor said we're giving tenants a little more time with this bridge so that counties have time to get their funding out. That expires September 30th, as many people may know. I have it on good information that that's going to be extended again. So I think a good timeline would be right at the end of this month, because they may have released updated language we can go over.
End of September?
End of September would be good. I believe they will have updated. Hopefully they update the language and not keep it as is, because the way it's written right now is incredible.
And we're talking about evictions for non-payment of rent. Is that
Exactly.
Okay,
and I don't even like to call it evictions for non-payment of rent. It's just resolution to issues of non-payment of rent, because the goal would be not, and this is always my goal, and I hope I have clients that share the same goal, which is to not evict, but to get the tenant access to funds to help them.
Or jobs, guys. Like we said at the beginning of the podcast, check the show notes if you're this far in with us, where we gave you some resources to help your tenants get jobs.
Right. And if they have jobs, then they're more likely going to be able to qualify for some of these programs. I'm going to let you and Joe circle up and book that. We do everything on Tuesdays, so that would be awesome. Yeah, sure, no problem. But that's my spiel, and now you know why I could do a 4-hour class on this stuff.
Yeah, well, maybe we'll do this like 3 times or something like that. We'll do the next one, and then we'll see what we have left to talk about. We'll just do like them once a month if we need to, or something like that. You have some new best friends, Kaitlyn.
Do you have any more questions about this? What about you, Joe? You've been so quiet.
I make sure that people get to see this information. I don't actually get to be. I'm not the expert on the real estate side of things like Julie.
Okay, sounds good.
That's right. We're all here.
I guess the last piece I have is just remember that if your property is located in a city or a county that has even more strict laws, whatever is more beneficial to the tenant is what you need to follow.
That might be Seattle, Federal Way, Burien, Auburn, could be more, but there's your starter set.
Right.
And is there any way, I guess, where do you go if you're in like, oh, dang, mine is in Tukwila, where your office is, or SeaTac? You just, where would you recommend people go dive down to the city level? Just the city website? Or
I'll be really honest. I go to www.google.com and
Googler, as my 13-year-old say, they don't say,
I mean, honestly,
I used to say Google it, but they say search it up.
Yeah, I literally just type in, like, the other day I typed in Tukwila Landlord Tenant Law 2021 just to see if Tukwila in 2021, if there was an article somewhere. And usually the information, or at least the information that I need to tell me something, pops up. And then I know where to search, right? So if I know the city ordinance or the city council acted in some way, then I know to go to the city of Tukwila' website and go to their code and look for their specific emergency code or landlord tenant code. And
does the RHA website keep up with any city stuff? Like, right. So just as I mean, there you go, right there. There's
RHA has form leases that are, they have the addendums that are all city specific. So whenever the city passes a specific rule about something that has to be in your lease agreement, for example, City of Auburn now requires this list of resources and a tenant handbook. As many Seattle investors know, you've got the tenant handbook that's like 39 pages, color copy, that's got to be added. All of that stuff, they keep track of that, and they will say, here's our form lease, and then here are the addendums that you need, or addenda you need for the city of Seattle or the city of Auburn or the city of Federal Way. They spend a lot of time and resources making sure that they stay up to date so that their members can benefit from not driving themselves crazy trying to keep track of this stuff.
Awesome stuff. Super resource. We're lucky to have it, right? Absolutely. Absolutely. So you, little housekeeping item as we wrap up here, because I have to go to an appointment and looks like Joe's getting hungry. Joe, you getting hungry?
I'm getting hungry too.
We've been talking about so much meaty stuff. I'm normally the starving one about 20 minutes into these podcasts, but today I feel like I'm full of knowledge. So what was the thing? Are you the meeting that's happening tomorrow that was too late for everybody to know about on this podcast? And we're going to put it out on our Facebook page. Mm-hmm. Send that to Joe, or send some information to Joe so we get the word out for sale.
I will send the link. I will send the invite to it so that people can sign up if they want to. I do think you have to be an RHA member to have access to it.
Okay.
So that's unfortunate, but I also think, hey, if you want to be a member, it's worth looking into. I'm making a note for myself, though, to send that to you.
Excellent. Well, I think we're going to cut it there today, guys, and we'll have Kaitlyn come back at the end of the month, 30 days from now, or sooner, whenever if she feels like she's ready sooner, just speak up. But that's a good call there.
Let's just touch base when Governor Inslee releases the new language or the extension, because I'm about 95% sure it's going to be extended because of the Delta variant.
Yes, the old Delta. All right. Well, we would love to hear from you. We want to be one of your partners, Kaitlyn, to help educate people and keep files off your desk, or if people need to use your desk, they know how to reach you. And how does that happen? If somebody's like, crap, I listened to all that and I already forgot everything she said. You can either call me and I'll send you all the links we've talked about, guys. Reach out to me, but more so, I don't really want you to, but you can if you want to, but you can contact Kaitlyn in her office. How would people do that? What's the best way to, if somebody's needing some legal assistance with this type of stuff, either tenants or landlords, what's the best way to reach you, Kaitlyn?
The best way is actually to email me directly at Kaitlyn@dimensionlaw.com. And that's KAITLYN @dimensionlaw.com. And usually if you provide me all your facts, I will send you over to my paralegal who will set you up for a formal consult. And I'll give 30 minutes of my time, usually to each consultation, because as you guys can tell, it's so incredibly fact specific that there's no such thing anymore with me as a 10-minute quick consultation. I have so many questions I have to have answered first in order to give competent advice. That's how they're panning out right now.
Yeah, it's interesting. You know what would be super cool? If somebody made a checklist, maybe you already have this. I'm a dork and I love stuff like this, of the top 10 questions to ask, or the top 10 information things to gather when you need to deal with a tenant landlord situation in regards to leasing.
I created what we call an intake form. So basically what will come back to you is an intake form with all the information that I need in order to give you the information you need on our consult. And sometimes
is that something that you can share with us, or is that not? Because then we can like say, hey, here's Kaitlyn's intake form, people, and we can. Yeah, that would be great. And if you're a broker out there, if you're a broker, this is really, really valuable information for you to know to assist your clients as well. So if you're a broker on my team, get excited about this, because I'm going to be giving all this to you guys. But
and let me just plug one last thing. If you're a broker, like I've had a lot of cases come across my desk where brokers are giving outdated landlord tenant information, or even filling out notice to terminates for their clients, and
bad.
It does not go well with your client when they find out that form was outdated or that information was outdated. And I would just really make sure, if you're a broker, now would be a good time to have an attorney in your pocket somewhere that you can just run something by if you can. Yeah.
Right. I mean, but having your checklist, like I'd like to hand your checklist to my clients and say, here's the information you need, call Kaitlyn. Right.
Well, I don't just call somebody that's up to date on landlord tenant laws. I'd like it to be me, but if it's not, I don't care. Just make sure you're taking care of your client first and arming them with updated information. Yeah.
No doubt. Well, this has been uber informational. I even followed along for a while. That's why I love that.
I'm sorry, it's so dry. I know.
Right? Oh no, this is total conehead nerd stuff. I love it. I love this stuff. So thank you so much. Yeah. We're going to wrap it up here because I'm going to meet a landlord actually. So Joe, where can everybody get the details of today's podcast? And guys, don't forget to join us on Thursdays, 11:30 to 12:30, where we can cover this kind of stuff again. I've taken copious notes. I'm going to have the recording before everybody else, and I will always have access to this. Happy to share it with you. Happy to talk about it with you. Happy to nudge Kaitlyn to see if you give me a heads up that maybe she can join us. Every once in a while, she's going to be busy. So, but don't forget to join us on Thursdays. And for those of you that are Seattle Investors Club members, our weekly roundtable masterminds are recorded. And if you're a member, you can access the recording after we've done that. Otherwise, if you're not, you don't have to join Seattle Investors Club. You can show up and join the conversation for free. It's free to show up and engage with your peers and learn massive nuggets that get dropped every week. Okay. But if you can't, it's $220 a year to join Seattle Investors Club. It's going to be the best $220 that you've spent in a while. So where can we find the details, Joe, of today's podcast?
Yeah, if you need to grab any of the links or anything they've talked about in the podcast today, head over to seattleinvestorsclub.com/149. That's seattleinvestorsclub.com/149. Or if you're watching this on YouTube, I'm going to put those links down below in the notes section.
And just a reminder, guys, /149 means there's 148 other shows and information that you can get. So we got detailed. This is what we do. This is what we're known for, the nuts and bolts. We go deep. And go to our YouTube page at Seattle Investors Club to overload yourself even further with such awesome information and meet all our smart friends and startups and all kinds of stuff. It's really fun. So if you have a show guest that you'd like us to interview or throw on our podcast, then you guys know how to reach me, or you can find the way to reach me. That's Julie at SeattleInvestorsClub.com. Let us know who that is. All right. Over and out. Thank you, everybody.
Bye.
Good stuff today. We'll see you in 30 days. We'll see you next time, Kaitlyn. Thank you.
Next time. Bye.
Thanks for listening to the Seattle Investors Club podcast. If you have questions that you'd like to have answered on the show, shoot us an email at info@SeattleInvestorsClub.com. Now go out, take that action, and build that real estate business. Thanks for listening.